Thank you very much, everyone, for joining tonight. My name is Ingrid Boudet, and I'm founder of No More Noise Toronto. And tonight we have a No More Noise Toronto meetup, a case for small claims court. Here we are. So we're going to go through a little bit of housekeeping. I'm going to go through an introduction of No More Noise Toronto for those of you that haven't had the pleasure of joining one of our groups before. And then we're going to go right into the presentation with Addison, and then we'll have a discussion afterwards and a little bit of a wrap up. So, No More Noise Toronto, we're focused on the noises that wake us up, keep us up, and disturb us day and night. We're a grassroots organization, and in 2 short years have grown to over 1,550 supporters. We have the support of FONTRA and FOSTRA, which is the Federation of North Toronto Residents Associations and South Toronto Residents Associations, and some of the groups within that. We are data and process oriented and engaged in the civic process at City Hall. So our approach has led to a collaborative discussions with 4 city divisions: bylaw, the police, Toronto Public Health, and Toronto at Your Service, which is 311. And we're also very happy to collaborate with other like-minded groups. So this is how did we get to this place where we now have to look at legal action? How did we get here? Well, in our 2 years, what we've discovered is that the city of Toronto, and maybe other cities as well, have a broad discretion on how they enforce their bylaw. And I learned this by going to small claims court and hearing a judge say that. So the enforcement actions are discretionary. They actually don't need to enforce the bylaws, and we cannot sue them for not enforcing the bylaws because of that broad discretion. So if the city can't really protect us, then what about Toronto Public Health? I've got a spelling error in there, sorry. Toronto Public Health, their mandate comes from the province, and they get 75% of their funding from the province. So if noise isn't part of those mandatory requirements and those mandatory programs, guess what? They can't do anything because, of course, resources are stretched thin. Toronto Police Services, well, in the case of motor vehicle noise, they really just don't seem to care. I've tried to engage them, and others on the call have as well, and we're doing our best, but they're one of those more reluctant dance partners, I would say. So that's how we got here. And when Addison reached out to me and he said, Ingrid, I think I have an idea that I want to run by you, but you have to be ready for something different. And I feel that No More Noise Toronto, we've been trying to do something different right from the first day, right from taking those measurements that are behind me. This is saying that we don't live with an average, we live with spikes, and we're presenting the data to prove it. So when Addison connected with me, and I was like, okay, here we go. And he shared his proposal with me. Legal stuff isn't everybody's thing, but it is for some. And so this is absolutely worth exploring. And I'm going to stop sharing now. And so this is absolutely worth exploring. And Addison, I welcome you to start sharing your screen and tell us what you got. You are on mute.
All right, does everybody see my screen?
Yes.
Okay, we can skip over this. I had more hair then, this is a number of years ago. But this is Canadian Corporate Counsel Association, and that's not a well-known magazine. But I'm a business lawyer, I do commercial work and regulatory work. I'm not a litigator, which might be a little unusual for those of you who've dealt with lawyers. This is really a citizen perspective on this, not a litigator talk, and it's a very practical one. And my actual job involving litigation would be to manage it, help direct resources, do it cost efficiently. Overwhelmingly, my work is for companies, not for individuals, over the last decade and a while. And I know the perspective of businesses on this. And everyone in this call is on the opposite side of that table on how do you get businesses to stop doing things? So this presentation is informed by me on the citizen side. I have actually sued someone in small claims court and won for something. This isn't total speculation on this. And I've helped my clients as well to deal with these kinds of things. And you're going to get a pretty unusual take on this here that's very practical and focused on this particular group. So first off, when Ingrid and I were first discussing this, the beginning of our conversation went on for quite some time about this of why other avenues don't work. But all of you have been doing this for a little while. You have some familiarity that unfortunately it's not easy to get action. Most people think class actions are the answer. In reality, there's not that many class actions in Canada. They take years and years. They require a lot of money. In real life, that's not really going to help people in a community group. I'm not saying don't do it. Same with everything else. Call 311, talk to your MPP, all of these avenues. Sure, those are for other kinds of presentations though. And instead, I'm going to tell you a really different one. And this is one that you probably won't really be able to read elsewhere as well, which is why I'm talking to you today. But here's the basic thing you're going to see in this presentation. Number one, understanding what strategy is being put forward here. Two, thinking about organizing with others. The strategy I'm going to tell you is way more effective when there's several people involved than if it's just you on your own. Yes, that's a good rule in life, but particularly in this strategy. Keep this one in mind. And then number three is implement, which is you going for it on filing a small claims lawsuit. This is practical. Real people can do this, and you can do it without a lawyer. Anybody who's dealt with courts or is a lawyer or knows about this, you've probably heard Ontario has a very dysfunctional court system. It's drowning. It is not going well in the court system in Ontario for a whole bunch of reasons. But there is a sort of different part of the court system than what most people know about, which is small claims court. And small claims court is really your last bastion of citizen justice. It's a little rough and ready for those of you who have any experience with this, but it is available. It's actually possible to do this as a regular person and go to small claims court. And what the strategy is about, though, is to take advantage of the fact that court is slow, annoying, and impossible to cover your real legal costs. This is normally a huge disadvantage for businesses because how it works is you get sued in a small claims court, and the maximum you can recover is about 15% of the claim. So somebody sues you and you spend $50,000 defending against the lawsuit, you win, and yet you still lose because you can only recover a small amount of your money against the person who sued you. This is very different from superior court, and this is a really important part of this strategy. So in small claims court, it's capped on what your losses can be as a plaintiff, and it's capped at a low amount. But the people on the other side usually have lawyers, and they're very expensive, and they run up huge bills, and then they can't recover them. And remember, what we're talking about is people who are noise offenders here. You want these people to have high costs they can't recover. That's the key to this strategy. So, several people suing. Why is that important? One, moral support. Talk a little bit about that later. But two, every person who's affected by someone has a claim. So somebody sets up an illegal garage doing muffler modifications, whatever thing they're doing, police won't hear your complaint. Everyone who's affected by it can sue that business independently because each person who's wronged has a claim against the person who caused that wrong against them. So you can have several people sue, and they can sue for the same thing or very similar things about how they were affected. And each one of those lawsuits costs them a lot of money to defend. So if you get 4 or 5 of these things going against some business, they're talking about real money that they're not going to be able to recover. And the idea here is to change behaviors by costing the people a lot of money. It's nice if you win as well. I'll talk about that. But the great thing about this strategy is even if you don't win, it's still great because you cost the other people a lot of money. And what you're trying to do here is to get them to stop doing something that's causing you harm. So even if you can't win your lawsuit, you can still cost them quite a lot of money on defending against it. And if there's a few of you, that's even better. Insurance may or may not cover the bill. This is important and relevant. Even if they have insurance, though, and they have a lawyer, you might think, oh, well, that's not very helpful because their insurance covers it. When people have insurance claims, their insurance costs go through the roof. Really, really expensive once you get a few claims, which they might if there's several of you suing against whatever business. And insurance companies are not in the business of paying lawyers enormous amounts of money with no results. Insurance company will pressure them to sort this out and to solve this problem as well. So it's actually good if they have expensive lawyers, which I'll talk about in a little bit as well. Also, setting aside lawyers and this kind of stuff, lawsuits are stressful, time-consuming, and they have to be explained to other people. Often people's loans have covenants in them where they have to tell the lender about being sued. They might have business partners they need to account to besides the insurers. There could be a number of other people they have to explain their behavior to about why they're being sued and why they're facing 4 different lawsuits for $25,000 and looking at maybe paying $100,000, which maybe that's not life-changing money necessarily for people, but for a business doing something bad that you don't like my illegal muffler example, for example, something like that, are they really going to keep doing it if they have to pay $100,000? Maybe they'll find something else to do that's not as noisy. That's another key goal here. Changing behaviors is really important. So just keep in mind, there's a lot going on with the lawsuit on the other side. It's not just about what you have to do. And you get the behavioral change by the impacts on the other side, on the defendants. Whether you win or lose, if you go to trial and there's a judgment, these things get published as well. That's really bad news for a lot of people and businesses too. They don't really want permanent public court records showing them to be doing something that's maybe illegal as well. Even if you lose, maybe what they're doing is illegal and it's just something that somebody else hasn't done something about yet. These kinds of things are the kinds of court records that allow other people in the government to maybe do something further with it as well. Lawyers in Toronto right now for decent litigators are $500 and up an hour. It's really hard to get a lawyer for $300 or $400 Canadian an hour. A good lawyer could be anywhere from $500 to $800 an hour. Even if they're doing some of it with staff, paralegals are expensive, articling students, associates, all of them are expensive. There's huge demand for good litigators. That's what the other side is looking at. Your lawsuit against them is going to take them a long time to sort out. And every hour that's being spent is another $500 out of their pocket. This piles up very, very fast and causes people to want a solution to that problem, which hopefully is to stop causing you whatever noise problem that created this in the first place. But it might be something better as well, like paying you. A lot of people settle lawsuits even when they have a really good case because it's so expensive to defend. Insurers do this, businesses do this. So in fact, the best case scenario for the strategy is that the other side has a really fancy lawyer. I know with my stuff with my clients, if they have some small legal problem, I love it when the other people hire really expensive lawyers to do the litigation because it means they're going to end that litigation soon because the bills pile up really, really, really fast. Lawyers do a great job. That takes a long time and it's expensive. So this process, actually, you can get money out of this. I'm not saying you will. Depends whether you've got a good or bad claim on this, but even a bad claim, people will settle bad claims and pay up as well. If they have to pay you $10,000, $20,000 to avoid $30,000 in legal bills that they will run up, they're going to do that. And insurers don't switch to self-representation. They don't suddenly fire the lawyers and say, okay, business owner, you're on your own. You go take on this matter. That's not how insurance works. So the insurer is continuing to run up those costs until they settle with you, and they want out and they want to do it on an economic basis. They don't care. They're not in the business of some sort of grand public policy thing here. They're in the business of sorting out your lawsuit as cheaply as possible. That's their job. This isn't that easy. I'm assuming you're filing a lawsuit yourself. That's the best way to do this because it's actually easier than you'd think. It takes some effort. It's not the easiest thing in the world, but it's possible for people to do this. Lots of regular people file small claims court lawsuits every day in Ontario. Requires time and organization. Expect to spend 50 hours or more on taking a claim through to trial. At least 50 hours is probably your personal time commitment on that. Fortunately, this is very symmetrical. The other side also has a long time commitment on their defense. And if they're looking at $500 an hour, that's easily 25K right there. And probably they're going to take even longer. It requires patience as well. This is a couple-year process. You might get a settlement a year into this, but to get this to trial and really get this disposed of, think 2 years on that. This isn't a quick win. It's not the police showing up at the door and stopping the people from doing it. It's you taking something and pushing it forward. It does require an iron will as well. I don't want to make light of this process. The defendants and their lawyers will try to say all kinds of things to you to get you to stop the lawsuit. Lawyers call that banging the table. They do this. The lawyers who defend against these kinds of lawsuits are often rude and really annoying because that's quite an effective strategy at getting regular people to stop doing things, is to make your life miserable as well in what they're doing. So be aware, that's a strategy, that's a tactic, that's okay. Ultimately, the only person who's really going to be hearing what you're saying is the judge. Along the way, they'll send you letters and other things, but where this really goes is to a judge, and they'll decide. The lawyer on the other side will not be the one who decides, so keep that in mind. It's also not free. It's pretty cheap, but it's not free. About $200, maybe a few $100s more if you have to hire what's called a process server to deliver the claim to the person. That can be a good idea depending on the circumstances of who you're suing. Keep that in mind. Probably that's where your real costs are. You might have some other costs around filing motions as well, but I would ballpark that at 200 to 500 bucks. Okay, I've been telling you all great things, right? Okay, sue these people. That'll be great. Maybe you'll get a bunch of money. That's not how life works. There's downsides, there's risks to things as well. What's bad for the mental health of defendants is the same for you. Lawsuits are stressful to go forward with, mostly because of dealing with the other people, but also because you'll be reliving the events that you don't like. You know, whatever noise nightmare will be discussed in depth. It's not fun. Regular people dealing with lawsuits, it's not very enjoyable. More importantly, you could lose some money. In Ontario for small claims court, it's supposed to be capped at about 15% of the amount that you claimed if you lose. So if you sue for $20,000, they should be able to recover around $3,000. And they'll have an easy time doing that if they have a lawyer because their actual bills will be enormously higher than that. And that's the limit. But $3,000, you know, that's quite a bit of money to lose. This isn't cost free. Don't file completely baseless lawsuits. Keep this in mind. There's some downside here. On the other hand, consider the process you're putting the other people through. Even if you don't have a great case, hey, maybe you'll win, maybe it'll settle. Worst case scenario, you're looking at probably around 3K that you'll be out of pocket if things don't go your way. And you get to court and you lose. Most lawsuits do not get to court. Most lawsuits settle. Strategically, you might not want to settle. You should generally take that position as well, that you don't want to settle. And you should try to get to a judge as the way to go forward. On the other hand, maybe there'll be a good offer. Maybe you'll say, yeah, you know what? I'll take that 20K. I don't like the noise. It's bad. You've shown these people something. Maybe they should stop. But there's your compensation out of it as well. So maybe you settle out of a lawsuit for 20K. That's not the worst thing in the world as well. Maybe they don't stop what they're doing, but you get at least some compensation for what they've done to you. Most importantly, if you miss something important about what you're doing, you might lose your lawsuit even if you have a good claim, and then that's the end of that lawsuit. You don't get a second kick at the can. So put your best foot forward, make sure it's a real claim. Make sure you include all the important facts and proof of whatever it is you're suing for. This does not have to be done in a scientific manner, but make sure it's all there so that the judge can look at it and the other side can look at it and understand what you're suing for and why what you're saying is true. Okay, how do you do this? You file a form with the government. It's called a claim. And then you serve the defendants with the lawsuit once you know their address. You have to have their legal name of the business or the legal name of the person to sue them. And then you have to deliver these things to them. There's quite the process for doing this, which is why a process server can make this a lot easier. Process servers do this for a living. They can even help you with the requirements of doing this because they do this all day, every day, tracking people down and serving them with documents. Consider getting a process server. It'll make your life easier. You don't have to do that though. Depending on the circumstances, you might know exactly who's causing your losses. You might know exactly who's causing that noise. If you know that, you don't need a process server probably. And then you might also require motions. You'll particularly find a need for this if the people are dodging you or the process server. In Ontario, it's quite easy to dodge lawsuits and drag things out for a long time, and a lot of defendants do this strategically. And you have to bring a motion or alternative service. So that would be something like delivering your claim by email or having a judge who's looking at this just decide, yeah, okay, actually, that was effective service what you did, even though it doesn't technically comply with the rules because it came to the attention of the other side. This might be something like serving their lawyer, for example, instead of serving the business directly. That's the main motion that a regular person would probably need to do is alternative service motions, because only once they've been served do the clocks really start ticking on this and the process moves forward. So it could take you a little while to track down the people and get them properly served. The raising the limit on small claims court, do you have to do the limit? I think some people file at the limit because they think, oh, well, that way I could get more money. Consider how much have you really suffered in dollars, costs, these kinds of things. It's probably not the limit. And consider what I said earlier about the 15% rule around cost awards against you. That's a good reason to not go higher. Because $20,000 suing for that, I keep using that as my example because it's less than the limit, but still useful in getting change. If you have 4 or 5 people suing for 20K, that's a lot of money. It's enough to get people to really pay attention to what your complaint is about. And maybe you don't need to sue for the max. Maybe you don't have that much in damages. Maybe it's a lower amount. So consider that. You don't have to file for the maximum. If you really do have a good claim for the maximum, sure. Be aware that there is a maximum, don't exceed it. But for this kind of stuff, strategically, I would think a lot of people don't want to sue for the maximum, especially because it increases your downside if you lose, which you might. You don't have to be a lawyer and to know exactly what a tort claim is or negligence to file a lawsuit. I'm including these words because they're good things to look up and maybe have some idea about. But for small claims court in Ontario, it's much more about the facts and the circumstances. The system doesn't presume that everyone is a law textbook and can figure out exactly what these things are. The judges will help to fill in the gaps there. As long as you can explain what happened to you, how the person caused the harm against you, how much money you're seeking, the justification for that, and your proof of the situation, this is far more important than trying to talk about legal principles and legal ideas. You can largely skip those and focus more on what actually happened to you and why is it bad? Why did this person cause that problem? Keep in mind, lots of people can sue. That's great. Key to this strategy. A whole bunch of lawsuits, way more annoying for the people to defend against. And also, you'll have some brothers in arms in that as well. It's a demoralizing process suing people because you deal with rude lawyers on the other side of the table more often than not. Or a complicated process that might be very disheartening. If there's other people suing as well, you'll be able to share stories, you'll be able to work together on that. There's a lot to be gained here in the strength in numbers, more on the moral side than anything else, but also in the dollar side. Because there is a limit on small claims court, but there isn't a limit on how many people someone can cost money or cause harm to, and each of those people have a claim. So it's not that someone can only be sued for the small claims limit by every person they've harmed. It's that the person who's suing can't sue for more than the limit. Oh, yes, you can't sue for other people as well. So keep that in mind. If there's several of you in a family who are affected, each one of you will have your own lawsuit. Okay, I've been alluding to this, but here's the math. If you go to hire a litigator, which you won't, but the people on the other side will, most lawyers are going to ask for $10,000 upfront. You don't really get to talk to them before you send them that $10,000 wire transfer, mail them that check. This is important because that's quite a bit of cash for a lot of small businesses or a person to put up. And if they have several lawsuits against them, that retainer amount's going to be even higher. Maybe they could get it down to 5K, could be 15K. So generally, lawyers are going to demand that amount of money up front, especially for the sort of defendants that we're talking about today. They have to pay that cash right now. And then the lawyer draws that money down as they invoice the client. So immediate pressure to settle, immediate cost to the business, immediate attention to this. Depending on who you're suing, their insurer would be covering that amount of money. Insurers don't like paying for things. They're not in the business of wasting all their money on lawyers as well. So it's no big deal if they have insurance. It might even be better. $500 an hour, as I said, depending on whether you settle early or it goes to trial, this is a 20 to 60 hour undertaking for these people. So at $500 an hour, that's 10K to 30K in legal defense. That's just the lawyers, and they're all but guaranteed to lose that money, other than the 3K they can get back from you if they win. Maybe they should settle your lawsuit for 20K if they're looking at a 10 to 30K guaranteed loss on the lawyer side. This is the key to the math. And then for you, your advantage here is that your downside is not that much because you don't have lawyers running up large bills. So for you, 3K is the max if you don't settle along the way. Most defendants are willing to settle for $0 if you go away. So if you think you've got a really loser case or your life circumstances change and you need out of the lawsuit, a lot of people are willing to settle for $0, even when they've wasted a bunch of money on lawyers, because they're going to have to keep paying lawyers if this goes forward. So they probably wanted to stop as well. This is really useful for the citizen side of things. The math is less good if they don't hire a lawyer. So this is kind of counterintuitive. People think, oh, if I hire a lawyer, I'm in dire straits. No, it's great. Perfect. The more expensive, the better. Premium law firm, excellent. They could be looking at $900 an hour. Perfect. If they don't get a lawyer, there's no ticking clock of $500 an hour, but it's really stressful for them. It takes time away from their business or whatever else they want to do with their life. They're losing money a different way. For a small business owner or somebody else, when they have to spend 2 or 3 times as much time as the lawyer, 60, 100 hours, whatever this is going to cost them, it's a lot of time out of their life. It's not a fun process. So it's not cost free for them either. You can offer to settle at any time. Keep this in mind. You're encouraged to settle in the Ontario legal system as well. It's good to go to trial as well and have a judge there and to see it through. But if you get a reasonable settlement and you can work something out with the other side, maybe that's good too. Okay, again, you don't have to be a lawyer to do this, but you do need a halfway decent assembly of the facts. Think photos, narratives. You can include links to video and audio as well that you've recorded, stuff you've done like this. This is all good. The more facts and proof you have of what you're talking about, the better. Judges want to see this as well. People are liars. They submit all kinds of stuff that's not true. So the more documents and proof you have, the better. In Ontario, it's often difficult to win a lawsuit without an expert. So for example, you say, oh, the noise was really loud. And the other side says, well, you can't prove that, and you're not a sound engineer who can provide expert evidence about sound levels. That's true. And yet also kind of beside the point, because in small claims court, you're not really going to have experts. Instead, you probably want to do this by way of affidavit. Find someone who's willing to sign an affidavit about what happened. That could be neighbors who were harmed. If you get several people on your street to sign affidavits that say, yeah, I've been up till 4 in the morning every day from this drill they've got set up across the street. It's a horrible noise. I'm going to lose my job because I don't have any sleep. And you can have a bunch of affidavits like that. Judges care about that as well. And you won't need that sound engineer expert to do that. So consider affidavits as the solution to your problem of lacking an expert to testify. Affidavits are good. You can file them for free as well. You just need to find your neighbors to come through with that, or other people as well. If you happen to know a sound engineer, they don't have to write an expert report. Affidavit would be fine as well. Consider this as the solution. The key thing here, though, is explaining what was done to you. Why was it wrong? What's bad about it? Focus on costs, damages, what you lost from what they did. I know that's a little bit different than what this group is about around noise being intrinsically bad, but noise can cost people money as well. For example, if you have something about how you are doing really great at work, and then due to this noise over the last few years, you've been demoted from your job because of your sleeplessness, blah, 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 this kind of stuff. Noise could cost people money. It could cost them a lot of money as well. So think hard about how you've suffered, what your losses are. They don't have to be calculated exactly, but they should have some connection to reality about that. And if you don't think it's that serious, maybe pick a lower dollar limit on what you're suing for. You want to write several pages. Don't rely on ChatGPT. Write this yourself. You could look at ChatGPT as some inspiration, but ChatGPT doesn't do a great job of these, at least right now. So actually write this yourself. Have it be in your own words. Have it be long. Several pages is good. The more photos or videos or audio explanations, the better. Focus on facts. You also need some sort of legitimate case. Again, you're not a lawyer. You don't have to finely craft this, but it can't be complete nonsense. Don't file a total nonsense lawsuit just to go and get the other people because they're bad guys. Have some basis in reality on what you're suing for and what they did wrong to you. You have to be negatively affected in some way. So for example, if you live across town from a construction site that's loud, but your friend hates the people doing it, don't file a lawsuit and say, oh, like I think the noise could have been bad if I might have been walking by there. No, it should be something where you're personally affected and what it actually did to you. Again, nuisance is the key word there, but you don't really have to focus on these legal terms. Focus on what they did. Why is it bad? As I said, things are better when you've got more people. There's a multiplier effect on the amount they're losing. They don't have great efficiencies from many defenses. Each defense takes time, and filing more of them also takes time. So it's not like 5 lawsuits is the same as defending against one, especially if they're quite different in their claims, because each person was affected differently. But even if they're basically the same, 5 lawsuits is more like 2 or 3 times the work, not 1 times the work. It's not 5 times the work, but they don't have great efficiencies on this. So more lawsuits is good. Also moral support. I wouldn't wait till everyone is ready. If you've got a group of people, file your lawsuits when they're ready. Move forward. Each person is an individual who's been affected differently. Ideally, have different claims in each lawsuit about how you've been affected differently. Everyone is affected differently by noise. Your physical proximity to the noise source, your encounters with the people, like that illegal garage example. Maybe you went over there and asked them to stop and they swore at you and were really rude and all these kinds of things. This affected you differently than the person who never confronted them, for example. Include all of these details. Have them be different. Don't just copy and paste what your neighbor is suing for. Have your explanation of how you suffered. This also happens to be much better because it makes it more work on the other side as well to defend against individualized lawsuits that are about real people and their losses rather than a generic claim that's copy and pasted between a few people. And judges aren't stupid as well. They'll see that. And the defendants will definitely bring it to their attention. So don't copy and paste. Have it be about you. What happened to you? Oh, also, judges, they are regular people as well, like you. They're sympathetic to people being harmed. A lot of people become judges because they want to do justice. They're not really against you. And in Ontario, many are particularly swayed by social justice arguments, as well as things that affect regular individuals, That's what people want to be doing. They want to be helping regular people against some person who's done an injustice to them. So keep in mind the judges will largely be on your side. That doesn't mean they're going to side with you. They decide on the law, but they're not hostile to you, despite the way they might ask their questions or deal with you on it. Law is a adversarial process. It's rather aggressive. Some of that is an act, so just be aware. The judges are not nearly as harsh as they might come across if you're dealing with them on this. You could hire a lawyer. You probably don't want to. If money really isn't a problem in your life and you've won the lottery a couple times, yeah, sure. Okay, fine. Hire pro lawyers. That's great too. They'll do a great job, probably better than you. For most people on a citizen type lawsuit, though, you don't want that lawyer because it's really expensive for you, and then you're going to want to out. No, the idea is for the other people to be the ones who are desperate to get out of the situation, not you. So don't run up those big bills. Do it yourself if you can. Paralegals are way cheaper. If you happen to know a good paralegal somehow in your life, something like that could work as well. Or they could help you a little bit. You could hire them for a few hours to walk you through the process, something like that. Maybe. Paralegals are very significantly cheaper than lawyers. Some of them are really good too. I've got a couple links here that are pretty good. That Steps to Justice one, that's referred to by the Ontario Small Claims Court system itself. There's some pretty good information on that website. It's not run by the justice system, but it's a good resource and it explains quite a bit about it. It can be sometimes tough to figure out the proper name of a business. I put a link here to a very not well-known search engine that I use all the time in work for finding business names. It works across Canada, but it searches for Ontario ones as well, which is quite difficult to do. So consider using that business search. So if you have the trade name of it, you might be able to find it through that search engine and save yourself some time on doing that. That's a good one. The government won't help you to sue someone. It's driven by you. This is totally a private process. To the extent they say they help people with this, they don't really consider this to be that you're on your own in terms of figuring out what you should put in that lawsuit and following through on it. You can sue the individuals who caused the problem and the company. And in fact, that's often the right answer because you may not exactly know whether it was the corporate actions that cost you the whatever, or whether it was the person who did something, whether or not it was authorized by the company, or perhaps they're the owner of the company. For smaller businesses in particular, these things are very enmeshed, and you probably want to sue both of them. If you're totally sure the individual had nothing to do with it, don't just sue a person just to cause them extra stress and hassle, because it's a little bit more work the more people you sue. It's slightly easier if there's only one defendant, but consider also if there's a key owner of this who is clearly doing the bad things as well, and there's not a clear separation, or if the company is bankrupt or something like that, include that individual as well, might be a good idea. Generally, you have 2 years to do this from when the harms happen to you. Historical harms that are outside of that 2-year window, maybe you could list them as background in your claim, but you're not actually going to be able to sue for those things in Ontario. The actionable rule is way more complicated than this. As with many of the things in this presentation, these are summaries that are a pretty good summary of it. There's quite a bit of nuance and detail to that, but just consider, in general in Ontario, 2-year limit on going forward with it. And that's pretty fair. You need to move forward in a relatively timely manner when people cause you some sort of harm. That's the idea here. There's no one way to sue. Lots of different ways to sue, how to put together a claim. If you see some guide online that says, oh, this is the only way you do it, that may not really be true. Small claims court is pretty flexible. Focus on facts rather than formatting your claim. Less attention to numbered paragraphs, more attention to having all the details that are in it. This is discouraging. Stay strong. Just remember at some point you'll be dealing with a judge and things will change and dealing with the other side's lawyer. Very good tip that's very confusing. There are 2 different government portals that are both a part of the small claims court system. If you don't see the right things online, you're probably looking at the wrong portal. If you go look at the small claims court filing online instructions from the government, you'll see there's two different portals there. Pay attention to this one. You need to use the right portal, and you'll be really confused if you're looking at the wrong one. Affidavits, can't emphasize that one enough. You may not even be able to win your lawsuit without an affidavit of somebody else corroborating something about the story or explaining something about it. Particularly useful instead of experts. Experts are too expensive. You almost certainly don't want an expert. Unless you know an expert is willing to do this for very cheap or free, experts are generally off the table. When they hear it's for a lawsuit, expert rates are very expensive, often cheaper than lawyers, but not cheap. Courts are somewhat public, usually somewhat obscure. So even a filed document could in theory be obtained by somebody else. If you are someone who's famous, consider this. If somehow this gets media attention, they might be able to get a hold of your claim as well. Just consider when you file things in court, they could become public documents. Settlements aren't published. Settling a lawsuit is one way to preserve your privacy. I was talking about it earlier from a money perspective. You might want to settle to not have a published judgment about you. If you have a sensitive job, if there's sensitive details that are in this, consider this. And consider really sensitive details. Maybe don't include them in your claim. Maybe you can sue without including sensitive details about your life. Give this a little bit of thought around your privacy. Also give some thought to disclosing your home address. Depends who you're dealing with. Sketchy illegal muffler guys, maybe you don't want them to know your home address because you've dealt with them and they're horrible people. That happens. Consider having a different mailing address. For example, virtual addresses, having a paralegal use their address. There's a few different solutions there, but just be aware that your home address is on that claim form by default. That's what you fill in. Maybe you can use a different address, a work address, something else for that, maybe, depending on the circumstances. Judgments are forever, often published, but not always in Ontario Small Claims Court. And with usually search engines are blocked, but we can't guarantee that'll continue to be there in the future. There's more and more people mining this data. We're in a world of ChatGPT where instantly things can become available about you. Be careful about this. If it goes to trial and there's a judgment, you probably can't get that removed. That's considered to be a public document. Very unlikely that you could get that sealed. Keep this in mind. A lawyer made this presentation, but they're not your lawyer and don't know your facts. There's a lot to law. This presentation doesn't cover everything about small claims court, not even close, but it covers the key things to consider for this strategy of how you can win against a noise source. And that doesn't necessarily mean winning your lawsuit. It means getting them to stop, or it means getting some compensation. It is possible that more than 15% could be awarded against you. That's prominent in my presentation. It is not a hard rule. There's actually not too many hard rules in small claims court. If you do a lot of bad things, for example, you are just incredibly difficult to deal with, or you lie about things, or you create huge amounts of work unnecessarily by, say, filing 10 different motions that are complete garbage, and all of them you lose on, yes, okay. They might have, a judge might say, your conduct was so incredibly bad that they're going to go higher than that 15% limit. This doesn't normally happen, but be respectful, be polite, don't file baseless claims, don't file baseless motions. And if you do that and you generally stick to the rules, that 15% limit is there to protect you as the plaintiff. Obey judges, do not disobey them on what they're doing. In theory, you could go to jail for disobeying judges in Ontario. In reality, nobody goes to jail. It's just their lives are hard enough. They're busy. They have a lot of cases. There's a lot of crazy people that come before a small claims court because it's the regular people's court in Ontario. So just be aware, be nice to them, be polite to the court workers as well. All of these people, they're completely overburdened. They are genuinely trying to help you, even when it doesn't seem like they are. So just give them a little bit of slack. Try to be polite in your dealings with those people as well, and you'll look better as the plaintiff. If you're dealing with horrible people and they've seen that you're a normal person who's polite and reasonable, well, guess who's probably going to win that lawsuit? When it comes to credibility of evidence, these kinds of things, most normal people will side with the person who's polite and normal rather than the jerks on the other side. So give that some thought as well. Lawyers on the other side aren't evil. They might seem like it. They're often very rude. They try all kinds of things to get you to give up to the very limit of what they're allowed to do, or a little bit beyond. In reality, in Ontario, lawyers are not that well policed by the Law Society of Ontario. And you might deal with aggressive tactics by these people. Try to move past it. Understand their tactics. That's okay. It's not personal. Remember, they almost always don't actually care. They've got lots of cases. This is just one of many they're dealing with. They get paid lots of money to do that. That's okay. It might seem personal. It probably isn't. And remember, they're actually helping you. They're running up big bills for the people you don't like. And that might force them into a settlement with you as well. Even better. So the fancier the firm, the better it is for you. Don't be like them, though. Be polite. Be insistent. Don't be a pushover. Don't feel obligated to reply to anyone, though. They'll send you mean emails to try to goad you into writing rude stuff to them back, things like that. You don't have to reply. You almost never need to reply to the other side. Lots of people feel they have to reply to things. You usually don't. Might be better to just ignore it. Give things some time to cool off, too. You never have to reply immediately to anything from the other side. Give it a day, give it a week. Your immediate response will be anger. They're trying to make you angry. They're trying to intimidate you. Just wait. Come back to it later. And keep your eye on the ball there, that you're trying to push this forward to get to a good outcome here. The other things along the way, with dealing with the lawyers, the defendants, just move past it. Remember, it's the judge who's going to decide this. So, recap. Best if they have a lawyer or insurance. That's what's really going to motivate them, those bills. Focus on facts, evidence, and the truth. When you sue, work with other people. The more plaintiffs, the better. It's a 1-year journey, 2-year journey. It's not a fun journey. Courts can only award money. Other courts can do other things, but Ontario Small Claims Court, only money. They can't make the people stop. Don't bother trying to sue court, getting them to stop. That's called an injunction. Small Claims Court doesn't do that. That requires a different part of the Ontario court system. So just remember, money. That's what's at stake here. If companies lose enough money, they stop doing things on their own. They will make the right decision. Okay. Q&A. Thank you very much, everyone, for listening to this tonight.
Thank you so much, Addison. That was a, if you can stop sharing, that'd be amazing. Thank you. I put a couple links in the chat that were in the presentation. They're now in the chat that Addison had. So I'm going to start off with just a couple of questions that I think most people will have. And so hopefully that will eliminate some of them. So I hear from most of these people on this call, and so I feel that you've addressed the motor vehicle scenario quite well. But let's take, for example, construction or waste collection or landscaping, the leaf blowers. So this is where does the size of the business matter? So there's somebody on this call here who's been pummeled by the building, and many people actually have the building of the Ontario line and Metrolinx. So, right, so it's Metrolinx and then it's the contractors and all that other stuff. So, and for waste collection noise, it's GFL, but then they often work with the Waste Collection Association or the Ontario Waste Association. So, what are some of the entities, who can we go after that we may get results, or who would you say don't go there?
Probably don't bother suing the government. when they lose lawsuits and they pay lawyers, that's not their money. They don't really care in general. Oh,
Right.
well, that's another 20K we have to pay somebody. They're already paying billions for the Ontario line. It's not going to affect their behavior. Ideally, the dollars at stake should be related to the behavior. Same with GFL. Are they really going to care too much? I don't know, maybe. If they're picking up waste bins and they get sued for 100K, maybe they're going to take more care in your neighborhood. Maybe they don't care about anyone else. They're like, oh yeah, you know what? Actually, stop making so much noise in that neighborhood because we got sued by those people and it's costing us a fortune to have some law firm defend us in that. Even big companies, they don't want to lose this money. It's expensive and people pay attention and they have little spreadsheets that show what lawsuits are open and how much things are costing them. And they come back to this every month, every couple months and look at that list. Hey, why
Yeah.
is this costing us so much money to defend this lawsuit in
Yeah.
the annex against these guys, whatever, right? Like
Yeah.
somebody will be paying attention. They don't care
Yeah.
much about your complaints. Those go in the garbage when you send them emails or whatever, right? Money, they care. The
Yeah.
government doesn't care much about it.
So back to your point of if they have a big stable of expensive lawyers, that doesn't matter. And that's where, so I
They,
just want to be clear, Metrolinx is the government?
I would say so. I mean, technically, I think it's a public-private partnership they set up with some kind of special
Okay.
entity. But yeah, it's the
Okay.
government footing the
Okay.
bills. But for contractors working on it, those people have their own insurance and they're paying attention as well. Insurance claims are bad news and they have to account to people for them. Small claims may not be material under their kinds of contracts. These people get sued all the time. They're very used to this rough and ready world. So
Mhm.
it may not be super effective against something like a Metrolinx super construction project.
Okay.
I'm not
I'm
saying
gonna
don't do it, but just be aware the results will probably be less effective.
I'm going to bring up another example. And so sirens and backup beepers, they are legislated by the province, but there are alternatives out there to the woo 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 that we have now called broadband beepers. And if those are allowed, so if the type of siren isn't necessarily mandated, but it's only that they use sirens, or backup beepers, because I've heard companies that just have those broadband speakers or broadband backup alarms. So if they aren't using the most up-to-date or quiet technology that they can, is that also something that then can go towards, I'm suffering damages because you haven't updated your equipment to what is available on the market now?
It would generally not be for you to say what they should be doing. It's only to
Right.
say how they've impacted you.
Right.
And who cares? Whatever. Louder ones, quieter ones, find some in Taiwan that do something better. I don't know. Like that's up to them. Like they need to source their own equipment. They need to stop causing you whatever damages. So the focus is much more on how you've been affected and not on how they're running their business. Because that generally doesn't really matter. It's just have they somehow cost you money? Have they somehow done something that is bad to you?
Yeah. So,
And
and
just
this
go
will
a
be my
little further
last.
with that. Like ambulance sirens, sure, maybe that's necessary and they use those things. But if
Mhm.
they park outside of your house and run them for 20 minutes at full blast, I don't know, maybe those can cause hearing damage if you're nearby. And it wouldn't really matter whether or not they're required to have sirens or something like that. Like they did something inappropriate that caused you harm about that. So in a
Okay.
lot of cases, I think it wouldn't even really come up. And judges know nothing about this and they won't really care either. Like that's too complicated for small claims court.
Okay, so this is going to be my last question, and then I'm happy to open it up to the group. And again, so I'm going to ask that. So examples of suffered damages. We are as a community have been told for decades, oh, you'll get used to it, and many of us, and me included, at first felt guilty. It was like, well, maybe I'm the problem. So sometimes coming up with those damages that we've suffered. So for me, I had to quit my job because I was living with those noise spikes, and I knew when they wanted me back in the office after COVID that I couldn't. There was just no way that was going to happen. So, but that is a real economic cost. There's all kinds of other costs. Could you maybe list some of those that from that we would suffer from noise exposure, just so that we kind of have a bit of a list in our minds of what we can pull from?
Before that, though, there's an idea that you You find your plaintiff as they are. The fact that someone's circumstances might not be what somebody else's circumstances are, and they suffered more by your actions, you caused that to that person. So somebody's unusual sensitivity to noise, that
Mm.
wouldn't preclude you from suing generally. Now, the other people are going to say that, like, oh, it's whisper quiet. This person has, I don't know,
Hmm.
for sensitive hearing like Superman or something. Like, is that really like how it is in real life? No. There's varying degrees of sensitivity to things.
Right.
The fact that you happen to be next to people with sensitive hearing issues, like they have the loud sirens next to a toddler's kindergarten where they're unusually sensitive to noise, it's not the toddler's problem that they're doing that. Like they need to stop what they're doing. So
Okay.
I wouldn't worry too much about the sensitivity thing. But also, everyone's going to say that. Every single defendant will say, "Oh, you're hypersensitive." Of course they will. Like whatever, ignore them. Like what did they actually do to you? That's the focus.
Hmm.
What would be some kinds of claims? I didn't include this in the presentation on purpose because everyone's life is different. And you said, Ingrid, I focused on the garage example. Let's just anchor this talk in something because
Yeah,
in
no,
real
absolutely.
life, there's millions of people in this city. They're all affected differently. There are so many different problems and so many different life circumstances. One person might lose their job because they were couldn't sleep from something. Another person might get demoted, or maybe nothing happened to them. Somebody might
Hmm.
end up in the hospital because
Yeah.
I don't know, their blood pressure spikes or something, and they have a heart attack from that, but it was actually caused by what happened. There's no way to know ahead of time what the circumstances are, and that's why I say focus on what actually happened to you. What are your real circumstances? What actually happened in that case?
Hmm.
But
Okay.
yes, anything that costs money in particular, that's an easy one. If
Yeah.
you've got hospital bills, well, you don't have hospital bills generally in Ontario, but physio bills, or I don't know, you needed some kind of private audiologist. I don't know exactly how you might be affected by this. Any kind of medical related costs, those are an easy one. Something to do with your job, that would be an easy one. Lost opportunities for things, if you can prove them, would be a good one. Like, I don't know, you were incapacitated by the noise, so you couldn't go and auction your wonderful work off in the Venice Biennial and you would have made millions. I don't know, something like that. Sure, yeah, there's your $20,000 claim easily made out. Totally depends on your actual facts.
Okay.
Think hard about those facts though, and they don't have to be just about dollars printed on receipts of your losses. That's good, but that's not the total end of the story. You can sue for nuisance of people creating terrible smells, terrible noises, these kinds of things. A terrible smell won't have a receipt, it won't have a dollar value, but it negatively affects people as well. And the legal system doesn't just ignore these other things about harms that people have suffered, but they should be somehow connected to reality. Like the garbage bin smelled one time for an hour, and yeah, you can't sue for that. But 4 years, and it was a huge issue in the neighborhood, and everyone tried to get them to stop, and they wouldn't, and all
Mhm.
these kinds of things. Yeah, sure. This is your last hope. Like this is the government. This is the kind of stuff that courts are for.
Yeah. Yeah. Okay. I'm going to do a quick little wrap up here. Much everyone for attending and staying so late. It's awesome. Great information shared. So thank you, Addison. So please consider this carefully. This is 100% your decision. We don't know where we're going to go with this, but I really felt that it was important that everybody had this information and could make their own decision. So if you don't know about us, please visit nomorenoisetoronto.com. We are a grassroots organization and we thrive on donations. Please sign up for Noise News. That's how we share our information out. And if you like what we're doing, sign up for a working group. We've got working groups for amplified sound, motor vehicle noise, construction, um, backup beepers and sirens and all of that stuff. So thank you very much for attending. So